And of course, to be members of the IEP team, parents have to have notice of the IEP team meetings. And as you'll see, we have to have these meetings obviously at mutually agreeable times and places because that's how we ensure that parents can participate. At times there can be meetings without parents if we can't convince them to attend. And hopefully we have interpreters in the meetings to, if necessary, to facilitate the parents' understanding if their native language isn't English. We have another regulation talks about special factors to consider in the IEP process, and it says that the IEP team must consider parent concerns. That makes sense, right? If the parents are members of the team and we want them to participate meaningfully, then the team has to consider parents' concerns. In some states, there's a division between the team that creates the IEP and the team that makes the placement decision. Not in most states, but if there's a separate team that makes the placement decision, the parents are also members of that placement team. And the idea here basically is the parents have a right of an opportunity to participate in IEP team meetings. And I think that the case law specifies it's a meaningful opportunity to participate, meaning I have enough information or I have enough of an understanding that I know enough of what's going on that I can provide input and I can be a part of the decision making process. And lastly, we have sort of a redundancy feature in the law. Obviously, if the parents have participated meaningfully in the IEP team process, they know what decisions have been made and why. But the law also says, in addition to the parents' participation, we want the parents to get this summary of the school's actions or refusals that happen in the IEP team process and why. And we're going to call that a prior written notice. And I'll talk about that a little bit more. And lastly, of course, parents are entitled to notice of all of these rights and safeguards that I've just talked about. And that's kind of it. That's the basis really of the regulations on IEP procedures and parent participation. Of course, here in the rights, obviously, I'm assuming that the parents have already provided consent to initial evaluation and placement and that the child is in IDEA so that the parents have all of these rights. I wanted to point you, if you wanted to look for these procedural safeguards, you guys have your Wyoming Chapter 7 rules. And if you look, those are your special education rules at the state level. And if you look at Section 6 and 7, they restate the IDEA procedural safeguards. They're not much different than the IDEA requirements. I wanted to make a point that IDEA is in and of itself a law that is heavy with procedures, and part of compliance with a requirement to provide an appropriate education is that you comply with the procedures of the law in creating IEPs. So a major part of procedural compliance is not only going through the process, but ensuring that the parents have a meaningful opportunity to participate. And we have two major Supreme Court cases. I'm not going to hit you with a lot of cases today, but you've got to know about the daddy and the mommy case of special education law. And the daddy case came in 1982, and it said an appropriate education under IDEA is one where the IEP is created in a way that is procedurally correct under IDEA, and then substantively that's reasonably calculated to confer educational benefit on the child. And not too long ago, the Supreme Court met again in another case, Andrew, and kind of retweaked it and said the school provides an appropriate education if, again, the IEP is created according to the procedural requirements of the law, but then the IEP is reasonably calculated so that the student can make appropriate progress in light of their circumstances. But what I wanted to point out for the context of our discussion, it's noted that both the daddy case and the mommy case in special education, which are our primordial cases that specify what an appropriate education is, start by indicating that procedures are part of FAPE compliance. That's how important it is. By the way, what is appropriate progress in light of circumstances? Well, the Supreme Court says is we're shooting for progress with every child, but obviously it's got to be commensurate with the severity and complexity of the child's disability and other factors that may affect progress. We want ambitious goals, but obviously that has to be based on the child's circumstances, because from one end of the spectrum to another end of the spectrum in IDA, we have very different students, from some students that have fairly moderate disabilities to students that obviously have very severe and profound disabilities. So what if you violate the procedures? Well, sometimes a violation of IDEA procedures is what I'll call fatal. And fatal in the land of special ed means you denied an appropriate education. The procedural violation is serious enough that it hurt the child's education, or more commonly, it seriously infringed on the parent's right to meaningfully participate. And if the procedural violation is severe enough to cause one of these two things, then you lost the case and there's been a denial of FAPE and there's exposure to liability. Okay, that's how important procedural compliance can be. If you have a procedural error, but it does not result in the loss of any educational opportunity to the child, it doesn't seriously infringe on the parent's right to participate, then it's just a procedural boo-boo. It's just a technical problem, but it is something that you can fix, but it's not fatal. It doesn't really cause a denial of FAPE. I want to quickly say, if parents disagree with decisions made by the district or the IEP team regarding their child in special education, what options do they have? And if you look at your procedural safeguards booklet, you'll see that parents have a right to file a complaint with the Washington Department of Education. These are called state education agency complaints. They can also request mediation, although that's voluntary. Both the district and the parent have to agree to participate. And then the parent can file what is called a request for an impartial due process hearing. Now, that's more like a special ed lawsuit, and it really looks a lot like a trial, although it's not in court. It's before an administrative hearing officer or an administrative law judge. But if the parent disagrees with the decisions that are made through the process, then they have these remedies, these mechanisms, these dispute resolution mechanisms available to them. I was asked, well, address the question of, well, when do these IDEA safeguards that you're talking about, when do they attach to a particular student? And I think that the first and most general answer is they attach when the child is referred to special education, because that's the beginning of the special education process. The child is identified for evaluation and potential eligibility. But under certain circumstances, they can attach even earlier, because parents can file a complaint with the department or a mediation request or a request for due process hearing, even if the child hasn't been identified at all, the child hasn't been referred at all, because the parent could have a claim that the district has failed to figure out that they should suspect that the child is disabled and they should have referred the child. So at times, procedural safeguards can attach even before the child has been referred to special ed if we've made an error, if we have failed to see what is present, and that is suspicion of disability and potential need for special education. Okay, let's start with the meeting process, the IEPs. Obviously, before we have a meeting, we provide notice to the parent that there's going to be a meeting, and the state decides how early in advance you have to provide notice to the parents. This isn't specified in federal law. It's early enough to allow the parents to fix their schedule and attend. And in this notice, you're supposed to tell the parents the basic purpose of the meeting, like initial meeting or review meeting, annual review, manifestation determination, or we're going to review a speech evaluation, whatever the purpose may be or purposes, the time and location of the meeting, the persons who will attend, not by name, but by position on behalf of the district. And you also have to provide the parent information that tells them they can bring anybody they want that they think has specialized knowledge or expertise regarding the child. Parent can bring basically anybody they want to an IEP team meeting. And who are the required members of the IEP team? What makes an IEP team? Well, here's the required members. You can see them in a nifty federal regulation, 34 CFR. That CFR, that means Code of Federal Regulations. If you googly those numbers, you're going to find a regulation that tells you an IEP team has to include parents, a regular ed teacher of the child, unless they're not in regular ed at all and there's no plans for regular ed, which I hope is rare, a special ed teacher or provider of the child, a local education agency representative, usually an administrator, and a person who can interpret the instructional implications, educational implications of evaluations. That can be a psychometrist or diagnostician, but it could be some other IEP team member. And the child when appropriate. And when is it appropriate to involve the child? Well, if they're old enough to provide and and they are savvy enough to provide input regarding their program. But I think primarily, I think it gets important to involve the child when transition issues as they get older, and we need to have the child's participation in the big question of what are you going to do after school is over, okay? So watch for state regulations that may require additional members in particular situations. You know, look at your Chapter 7. What about related service providers like OTs and PTs? They're not required really under the IDEA regulations to attend IEP team meetings, but certainly districts may want to include them when related service evaluations are being reviewed or related services goals are being reviewed or we're making changes to related services. It might be a good idea to involve those related service providers in those situations. I've sketched out a slide that says, you know, if you ask me, what are the roles of the various members? You know, I see the IEP team as sort of a pie, and each of the members brings their slice. Like parents provide input on the child as state their concern. Regular ed teachers, obviously, they tell us about what's going on in the regular ed classroom and how the child's performing in the regular ed classroom, what accommodations he might need or not need, what behavior intervention plan might be necessary. Special ed teachers, they provide input on present levels of academic achievement and functional performance of the child, on annual goals, and on the services that the child may need. The LEA representative provides input on all areas, and they know about resource allocation. Who do we have to go to if we need a fancy augmentative communication device? And they know about the teachers and they know about the curriculum. Evaluation staff, obviously, they can answer questions about evaluations and they can review evaluations. Related service providers, they tell us stuff about the related services, including the levels of performance in, for example, fine motor skills, let's say for a child with occupational therapy, and about occupational therapy goals and what occupational therapy the child might need. So who's the boss of the IEP team? There isn't a boss. The regulations identify no member of the team that has extra or superior authority except the parent, because obviously the parent has the IDEA safeguards that we talked about earlier. Parents can ask also for independent evaluations. Other staff can't, but even the parent's not the boss. The idea is that IDEA envisions a decision-making approach that's team-based, that's collaborative, that strives for mutual agreement between the district members of the team and the parent. That's the idea. So no, the LEA rep is not the boss of the team just because they're an administrator. They just bring their piece of the pie and their knowledge to the process. The team decides, and we're in agreement with the parent or not. So this confuses people. Prior written notice happens after the meeting. How is that? How is it prior then? Here's the deal. So the idea is the prior written notice is issued after the team makes their decisions, but prior to the school actually implementing them. And the idea of this prior written notice is that it's a redundancy-oriented procedural safeguard. So aside from participating in the meetings, the parents get this written summary in writing of the bottom line decisions made by the IEP team to assist in their understanding of what happened in that meeting so they can know whether to agree or disagree. And I think Congress understood that, you know, the IDEA process can be complex, especially if you're new to it, and that parents needed all the help they could in understanding what is going on and why, because that prior written notice does that. So the prior written notice is issued after the team makes the decisions, but before we implement them. Gives the parents a little bit of a time period to go over the decision making, think about it, talk to their spouse, decide whether they really agree or not. So prior written notice is required every time that the IEP team makes a decision. And also when parents revoke consent, if that happens, if the IEP team is going to implement a decision with which the parents disagree, we have to issue prior written notice, but we have to issue prior written notice even if the parents agree with the action. Here's the contents of the prior written notice. We have to tell the parent, here's what we did. Here's the decisions that we made. And here's why. And here's the databases that underlie our decision. And we're going to also tell you, Mom, as part of the procedural, the prior written notice, we're going to remind you, you have all of your procedural safeguards available. Here's even additional sources where you can go understand the process a little bit better. Other options that maybe we talked about and why they were rejected, and any other factors relevant to our decision making. Okay, so what if the parents don't speak English or can't read? Well, the prior notice has to be provided in the parent's native language or other mode of communication. Because if the parents are illiterate, because sometimes it's not a written language. So maybe you have to translate the prior written notice orally or by other means. Now, I was asked what else has to be provided in the parent's native language. Well, if you look at it, we are told there should be interpreters if the parent can't understand their English, if their native language is different in the IEP team process. But as far as documents, the only document that IDEA requires it be cast in the parent's native language is the prior written notice. But you guys might want to decide as a state education agency what other key documents you might want districts to provide in the parent's native language. Maybe notice of safeguards, maybe notice of meetings. Okay. That depends, and that varies from state to state. When do you give this notice of procedural safeguards to the parent? Well, you give it a lot up to the point that the parents are sick of it, right? So parents like, groan, are you giving me my 10th copy of the procedural safeguards? Yes, ma'am, because we have to give it to you at least once a year. And upon referral, if you file a state complaint, we have to give it to you. If you file a due process hearing, we have to give it to you. Disciplinary changes in placement, here goes another one. Or if the parents request. Generally, the procedural safeguards notice that's an easy requirement to observe because you just give them a copy of the procedural safeguards notice that generally the state has put together. And I've seen yours, I've seen yours. And by the way, yours, as is the case with many other states, is complicated. It's a complicated thing. There's a lot in there in the procedural safeguards. Your procedural safeguards booklet is over 10 pages or something. So is ours in Texas. So when you first provide that procedural safeguard booklet to the parent and the parents are looking at it like this, understand that you might give them a quick explanation of the big hits of the procedural safeguard and tell them, read it on your own, highlight the stuff that is Greek to you, come back and ask us about it, and we'll help with you.
Jose,
Yes.
I just want to mention that I did drop a link to the Wyoming procedural safeguards in the chat for everybody. Also, Chapter 7 rules and the federal IDEA regulations. Those are all in the chat.
That notice of procedural safeguards, I have been asked quite a few times by college students and other folks, how do I start learning about special ed law? And I often tell them, go to your state education agency website and grab a copy of that procedural safeguards booklet and start learning with that. Because if you learn that, you're going to know quite a bit about the special ed process. I've devoted a few slides to a point that I want to summarize, and that is we make decisions at the IEP team meetings. We don't make our decisions ahead of the time and then foist them on the parent, okay? Decision making is supposed to happen at the meeting. And when you do it incorrectly and really you make your decisions prior to the IEP team meeting, and no matter what the parent says, boom, we're just going to do what we thought about before and what we planned. It's called predetermination, and it can form the basis for a legal claim. And this claim became more popular after a celebrated case from 20 years ago called Deal v. Hamilton, where the school just refused to do any ABA programming. And the court actually agreed that the school basically was of the position, we're not going to do ABA no matter what the parent says or what data is provided. And there were some damning emails that were sent by the special ed director that appeared to support that notion that it didn't matter what the parent was going to say. The outcome of the meeting was going to be, we're not going to do ABA or incorporate it into our IEP. And the parents were awarded private ABA program, and it was a painful lesson for that school district to learn. So we don't pre-decide a child's program before the parent provides input. No, we can have ideas, we can have notions, we can have options, we can think about it, we can prepare. But if we just decide outside of the meeting what's going to happen tomorrow's meeting, you're rendering parental participation meaningless. And obviously, that's a procedural violation that seriously infringes on the parent's opportunity to meaningfully participate. So it's okay to have opinions and ideas prior to a meeting, but you must be of open mind to other options and suggestions. How do you show that you are of an open mind at the meetings? By seriously considering the parents' positions and proposals, talking about the pros and cons, being willing to accept some of the parents' proposals if reasonable, if they make sense, by explaining why you're not going to do something that the parent wants if it doesn't make sense, or you're going to do it in some other fashion. That's how you show you are of an open mind. If you prepare notes or draft documents ahead of time prior to meetings, which is okay. I mean, you're not drafting every present level of performance and annual goal at the meeting. Can you imagine? Meetings would take days. But you have to make sure that those documents are marked draft only, and you should make clear to the parent, this is only a draft that we prepared to facilitate the discussion, but it's open for consideration. And at meetings, everybody that participates should be open to opposing viewpoints and submit them to that marketplace of idea, to the pros and cons. All ideas have their pros and cons, and that's how we decide. And in making placement discussions, we should have various ideas about options to discuss with the least restrictive environment considerations at mind. I've been asked this question in the past, and I use these a lot, which are, what are helpful things to say or ask in IEP meetings? And I think, well, when I'm in an IEP meeting, you know, what have I done in the past that I think helps? What have I said? I like to throw things out to the committee. Like, what does the committee think about this? Like, if I have an idea, I throw it into the marketplace of ideas. If the parent has an issue or concern or question, I like to ask, what data should we look at to answer that question? Does the data support the parent's position or not? If the parent says, I think this should happen, I like to ask, what are the pros and cons of X position? If there's really other ways to skin that cat, are there other ways that we can accomplish this? Have we thought about this? If it's a question really that's educational and has to do about the child's performance in the classroom, I'm going to turn it over to the teachers. What do the teachers think about this? If it's a question that really has to do with evaluation data, I'm going to ask, what does the evaluation say about this? I think those are helpful questions. They direct us back to the data rather than personalities. I've gone positive first, but here's the negative. I don't like to hear the following things at meetings, okay? And I don't like to hear them because you could have a snarky answer come back at you, okay? We've never done that. If I was a parent, I'd say, there's always a first for everything. Hooray. You're going to enjoy this new experience of doing this for the first time. We have to get approval for that. No, you don't. Actually, the IEP team's the boss. If you guys say it has to happen, it's going to happen. So isn't that cool that you don't have to get approval for that? I looked that up and I found out you don't. You don't have to get approval. And if you have to get approval outside of this, that's weird. That's actually not the way it's supposed to work. We don't have the resources for that. Yes, you do. Come on. Don't you take taxes, don't you? And you have budgets. You have a big old checkbook. Doesn't the district have a big, massive checkbook it can write checks on? Oh, so no. And if you don't have the resources at the campus level, then you do it at the district level. If not at the district level, we got to figure it out, but the resources have to be there. There are other kids in the class, and the parent's going to say that are not necessarily my kid. That's not a good thing to say because the parent can easily say, but yeah, I'm great. I'm great with those. Their parents care about them, but I've got to care about mine. That would take too much time. Time we got, and if we put our effort to it, it may take less time. That's the standard amount of service. That's the standard amount of counseling a child gets. Oh, that's weird. There shouldn't be standard amounts. Isn't the whole thing about an individualized determination of how to meet the child's unique needs? And that there's going to be variances in what the child, absolutely. There's no standard amount of services. I mean, we're almost saying there, we're going to go ahead and violate the law here. This type of student gets this. Well, that's just not how it works. We don't make decisions based on the type of student. We don't make decisions based on some idea of standard amount of services. We make decisions based on the student's needs. And then we understand the needs from the evaluation data. That's how things work under IDEA. Now, before I move to the next topic, might anybody have a question? I've meandered through some fairly well-tread areas in special education, but also areas that can raise a variety of questions in specific situations. Anybody want to raise their hands? Anybody want to throw in something in the chat? Miss Eisenhower, do we have anything?
We don't have anything, and thank you to two people who said they couldn't, the chat was disabled. I hope that I fixed that and that you can get those links to Chapter 7 rules and procedural safeguards. But there, not a single soul has put a question in the Q&A for you, Jose.
If that light bulb goes off, just stop me. Because I'm happy to take questions. I like questions. For me, questions, no judgment zone. Okay. All right. Let's move on. Let's talk a little bit about confidentiality of student records and information. Um, there's a couple of laws about this that kind of we need to know about. Um, the first is FERPA, Family Educational Rights and Privacy Act. It's crazy, but it took until 1974 for the federal government, for the Congress to pass a law that definitely ensured that the school would provide access for parents of their child's education records. And it did more than that. It also provided some privacy protections. The idea that, hey, to some degree, we want to protect the privacy of student records. And there's federal regulations that implement FERPA, that law. And there's, if you look at IDEA, there's a few IDEA regulations on confidentiality, but if you look at them, they mostly reiterate that the FERPA protections are also applicable to special ed records. Because I want to indicate that with respect to federal law and confidentiality, regular ed kids records, special ed kids records, they're equally confidential, okay? Special ed records are not super confidential. Regular ed records less confidential. No, all education records are equally confidential, okay? So FERPA basically applies to any school that receives federal funds. That's you. And it's got two purposes. It makes sure that parents can access their kids' education records, and it makes sure that there's some limits on disclosure, that there's some privacy protections to educational records. And parents entitled to annual notice of their FERPA rights, which you guys usually probably do through your websites or board policies. This is rare, but it happens. Parents can request that changes be made to records if they find them to be in violation of privacy, misleading, or incorrect. And there is enforcement. Parents can file complaints if there's a violation of confidentiality. So the basic idea here is that FERPA provides parents and adult students access to their education records and provides a measure of privacy protection to student records and the information in those records. So what is exactly an education record? Well, an education record is a record that relates to a student and is maintained by the school or somebody that's acting on the school's behalf, and it contains personally identifiable information. That's pretty broad definition, but there are some exceptions, okay? So it's almost better to understand what an education record is by understanding what an education record is not. And I'll tell you a couple of situations where it's not. So if you as a staff person keep some notes and you keep them in your possession, and they're mostly memory aids, they're to help you remember, and you don't make copies and give them to others or reveal them to others, except maybe your substitute, then actually those are not education records. Those are your notes. Those are your private property. You know, example would be a counselor who takes notes and they're not put in the file. They're just notes to remember for the next session, and they're not put in the child's file. They're kept with the counselor's private property. Those aren't accessible under FERPA. If you take notes during an IEPT meeting and it's just to help you remember for the next IEPT meeting and you don't put those in the file or share them with others, again, those are your property and parent can't ask for them under FERPA. Same if an administrator makes notes of a meeting with a parent. All of those would be example of not education records and not maintained by the school, and they're just kind of limited use for you. District police records are not accessible to the parents if they're for law enforcement reasons, but watch out. I do want to comment on cops and records, okay? What if police come to your campus and they want records on a child? Unless some exception applies, you can't disclose student records to the police. And you'll see later, I'll talk a little bit about exceptions to disclosure. You can disclose records to the police if they have a court order, for example. But if they don't, you have to politely tell them, under federal law, we cannot give you copies of student records unless you get the parent to consent to us providing them to you or you get us a court order. I mean, we'll love to facilitate your investigation, but we can't violate federal law, and you're a law enforcement officer, so you should know. Now, what if it's your own police officers, your own employee school police officers? No, then another exception applies because those are employees with a legitimate educational and safety interest in the child, and you can provide them the records. That's employees. Basically, alarm bells should come out if somebody that's not employed by the school asks for a student records. The initial answer should be, no, you can't access the records unless I check and some exception applies. Parents can't access records relating to a school employee, and sometimes they can access employment records through other state open records laws. And records of students over 18 that are maintained in connection with physical or mental health treatment also are not going to be accessible to parents. They're not education records. What about test protocols? I've been asked that by school evaluators. Well, we got this parent that wants a copy of the test protocols. Test protocols are these kind of scoring devices and scoring sheets that you use to score, for example, an IQ test or an achievement test. And generally, they don't contain personally identifiable information, so they're not necessarily FERPA records. But even if they are FERPA records, sometimes they're copyrighted because there's test security issues in there. And those are actually produced by a manufacturer that doesn't want them out in the open. So, yeah, there may be situations where those protocols are needed because the parent has reasonable questions about an evaluation, in which case the way you provide access to those records is by sitting down with the parent in those test protocols rather than providing copies, which might violate copyright. You tell the parent, come on in to the office and we'll look at those test protocols together and we'll try to answer your reasonable questions instead of providing copies of those test protocols. There's other definitions that are important. You know, there's some information that people just generally don't consider to be that private, like the student's name, their photo, what sports they're in, honors they've received, the weight of a linebacker. Okay. So there's certain categories of information that are considered directory information, not generally considered private unless the parent says, I don't even want that to be disclosed. And disclosure, by the way, means releasing the information by any means, by providing a copy to somebody or telling them what's in there, emailing it. So disclosure can be a release of information through any means. So information that's recorded in any way can be a record, including handwritten stuff, video, audio, emails. Oh, let's open that can of worms. Let's go fishing. Watch out. Emails are records, and if they pertain to a student and contain information that's traceable to the student, personally identifiable, they're educational records, meaning parents can get those emails. Okay. So that's become a hot topic because nowadays there's so many emails. When I started in this business, we didn't do email. When I started in this business 35 years ago, geez, we didn't have email. It was back in the Paleozoic. Those of you Generation Xers and Zers and so oners, you lived always in a world of email. But I assure you there was a world before email and business got done. But now we do so much business on email that there's a multiplicity of records and be careful because I think emails regarding a student that can be traced back, I think the parents can be able to access them under FERPA. And emails don't ever go away. Oh no, we purged some emails. There is no such thing. Look, I'm a fan of murder shows, but I mean real murder shows. I mean like 48 Hours where they're really investigating murder. I watched a show once where the guy that committed a murder had evidence in his hard drive. Okay, so he took his hard drive, smashed it with a hammer, threw it in a deep lake in Minnesota that iced over in the winter, thawed up. They retrieved the hard drive, and some computer nerd got all of the information out. That's when I learned never does an email go away. Okay. And
Hey, Jose,
yes,
there's a question.
sure.
What about text messages?
Text messages, there is no case out there that has said that something as ephemeral as a text message, which probably cycles out of your Apple Watch or phone really quickly, is ever going to be a FERPA record.
Okay.
But I got to tell you about text messages, especially text messages between parent and staff persons. I think you want to have a record of the back and forth between parents and teachers. And if you're a teacher and a parent wants to text you and it's starting to get kind of important, tell the parent, hey, look, I'm more comfortable if you communicated through email with this so that it can be properly kept and my responses are properly kept as well. But unimportant stuff, that's fine. Look, I used to tell people limit the stuff you do on emails, and I've realized, but you can't. You can't. I mean, this technology, it's with us. And it does make life easier. So, I mean, on unimportant stuff, I think text is fine. But if it starts getting important, tell the parent, I'm going to email you about this and you respond back, or put this to me in an email and I'll respond back. And I think that's better. If you're writing an email on a student, whether to another staff person or to the parent, I think a good frame of mind is write it as if the parent's attorney is going to read it. Well, the parent doesn't have an attorney. Just act like it. Act like the parent has an attorney. Would you like him reading this? If your answer is no, revise that. I've had a rule in my practice where I never early in the early days I never wanted to write a letter if I was mad. And then in the days of email, I never wanted to write an email if I was mad. No, it's just not going to come out right. It's just not. And later on, you're going to be embarrassed when you see it. So just wait. And again, uh, with parents, careful in your communications. Act as if a parent's attorney is gonna read this. By the way, another point of advice or kind of a practical tip: if you and a staff person need to communicate regarding a child and it's kind of sensitive, it's kind of about, are we in compliance? Did we mess up or not? Or what do we need to do? It's starting to get into legal compliance issues. your alarm bell should tell you this is a phone call thing, not an email thing. Okay. Discussions about what do we need to do to comply, sorry, those are best had in a face-to-face meeting or a Teams meeting or a phone call. I found that with my younger clients, I have a hard time getting them on the phone. My younger clients want to do everything over email and they want to do everything by text. And I tell them, but sometimes it's better if you talk to me because as we talk, I start thinking, wait a minute, you said something that lead me to something else. And now I'm realizing that the question you asked me isn't the question you should be asking me. Let's ask the question that should be. So sometimes it's good to talk. Okay. Sensitive stuff, meeting, phone call. Okay. Not emails back and forth because I want to tell you something else. So let's say you have some emails and they're not FERPA records because they're not maintained necessarily centrally by the district, but they're out there and they don't have personally identifiable information. It could still be subpoenaed because if you're in a lawsuit, you're going to have to produce any email that pertains to the child, even if it doesn't have the child's name or personally identifiable information. So again, careful with your emails. Um, when discussing students, stick to facts, avoid opinions. Sensitive matters should be in a face-to-face meeting, telephone conversation. Even if you use only initials and first name, doesn't help you. It can still be subpoenaed. It still relates to the child. In fact, I think that if you're writing emails that really serve to document what's going on and are really serving as a substitute for a written document that goes in the file, you really should print those and keep them permanently or keep them permanently in your servers. So study your purging practices. How does your computer system get rid of emails? Because you don't want the computer system to be eating up emails that you would have preferred to print and put in the student's file because they document something you want to document. Okay? Because emails can be helpful in a case. Nowadays, if you're in litigation, I know Wyoming doesn't have a lot of litigation, but I'll give you experience from a state that does have a lot of litigation. Nowadays, in our due process hearings and our special education hearings, we have hundreds of pages of emails and they can be evidence. So be careful with that. And if you lose emails and you know they existed, there's some doctrines in law that can hurt the case if you inadvertently got rid of some emails. But anyway, let's turn topics to student and parent rights under FERPA. So under FERPA, either parent has full parent rights to access student records, even if divorced. Okay? Even if divorced, generally, um, divorced dad, divorced mom, they have equal access to the student records. Why? Well, because we want parents to be invested and participate and interested in their child's education, right? So unless some court order says otherwise, that this dad is so deadbeat that he can't access the child's records, then even a deadbeat dad has the right to access his child's records and have some interest in their child's education. And in divorce situations, sometimes this can be sticky because you got mom saying, no, I'm in a nasty divorce with dad. I don't want him. Why are you giving him records about my child? Well, because he's the dad. And under federal law, we have to. I don't like that. Talk to your divorce attorney. And in some cases, you'll have to look at the divorce decree, or your attorney may have to figure out if there's any limits on parent rights. Generally, we look at those divorce decrees to see if the parents have equal decision-making rights, which obviously would mean that they have the equal rights to records, or whether one parent has the decision-making rights and they have to consult with the other. And you'll look at that. I've had situations where I've got divorced parents and they just won't agree with each other. And I think how to deal with those kinds of disputes is to tell them, guys, you're involving us in a post-marital dispute and we can't deal with it. You guys need to decide how to do this, and if you can't, you need to go to your divorce court and your divorce attorneys to figure it out, but then come back with some idea here, because otherwise usually it's become the norm in the United States that divorced parents have equal decision making rights. In the old days, it used to be one parent has the decision-making rights, must consult with the other, but one parent has the final say. But it's become, in the modern era, it's become of vogue for courts to say, you guys that couldn't even stay together need to make decisions together. Okay. All right. That'd make terrible amount of sense to me, but that's kind of the way it works. What about when kids turn 18? When kids turn 18, their FERPA rights transfer to them. This is one of the reasons why, if parents have a severe and profound child who can't really exercise their own rights effectively because they're incompetent in the eyes of the law, it's important for these parents who obtain guardianship of the child as the child turns 18. Because if they get guardianship, then they have access to the child's records. Because otherwise, it can get sticky. Because it's this 18-year-old student is the adult, and he's the one that's entitled to access his records. And yeah, it means the parents cannot access those records unless that student consents, and he may not have the capacity of consent. It's one of the reasons, among many, why guardianship of kids that are more severe in their disabilities and can't really make decisions on their own behalf is important. It's important for parents to plan for this before the child turns 18. Oh, by the way, there is an exception if the child is if the adult student is a dependent or it's a health or safety issue, you can still give the records to the parent, even if they didn't get guardianship. And in those situations, it's very likely that the child is a dependent. What is a dependent? It means the adult parents are providing more than half of their care. And that's going to happen in the case of more severe students. Hey, parent asks for records. How quick do we have to give them? I've had parents request, I want all my child's records. Child's 20. They want all their child's records from the time they were 3 to the time they were 20. It's 7 boxes of records to be copied, and the parent wants them by tomorrow. Is that's not reasonable? And the idea of FERPA is that records requests must be honored within a reasonable time, but never more than 45 calendar days. So you don't have more than 6 weeks or so to provide records. There is an exception. Now turning to an IDEA regulation, there is an IDEA regulation that says if parents need some key records prior to an IEP meeting or a resolution session, that happens when there's a due process filing or a due process hearing, you have to get the parents the records faster than 45 days. Okay? So there may be situations where you have to expedite the records access process. By the way, parent access of records also means that if they consent, their representatives can inspect records. Can the parent's advocate ask for all the child's records? Yes, but they have to have a parent consent. But if there is a parent consent, they have the right, the representatives have the right to inspect the records, access the records, and even ask questions about them.
Hey, Jose,
Yes.
we have a question and I inadvertently deleted it. Trina, I'm going to unmute you. Do you want to ask your question? Can you, Trina?
Can you hear me?
I
Yeah.
can.
All
Go
right.
ahead.
Hi,
So
Ms.
I had a
Nicole.
hi, hello. I've seen many of your presentations and I always appreciate them. So thank you for doing this for us today.
Very kind of you.
My question was around statute of limitations on
Yes.
communications or other IEP paperwork. My understanding is like under due process, there's like a statute of limitation of about 2 years. But then I know also parents, a new thing, or not new, but a common thing anymore is filing discrimination suits with OCR. So I'm just wondering, as you were talking about our purging on emails, what should we be looking at? How long should we be maintaining these communications and paperwork?
Educational records, anything that's an educational record under FERPA, the time frame for maintaining it is established by the state, and it is some time after you cease providing services to the child. So actually, the child's kindergarten grades, for example, would be maintained until several years after the child has even graduated. So you probably have a state records retention schedule.
We
Mine,
do.
Mine requires that we maintain in Texas, I'm in Texas. So in my state, we have to maintain education records, special ed records, etc., for 5 years after cessation of services. It's going to be 5 years after the child's dismissed, let's say through graduation or ages out. So it has no reference whatsoever to the statute of limitations for the claims. Yes, you're right. Due process hearings may be limited to claims in the past 2 years. And actually, OCR complaints are limited to issues of the past 6 months. But that has nothing to do with how long you have to retain the records. You'll have to retain the records much longer. So that's part of determining what's an educational record or not. Because if you've got an email that's really an educational record that should be in the file, that should be maintained on a long-term basis, years after the child graduates or you cease providing services. You'll keep those for a long time.
Thanks, Trina. And I know that we do have through archives something about retention of records. I'll look and see if I can find a link to that and drop it in the chat. Thanks, Trina.
For now, we can say it's going to be several years after you stop providing services to the child. And then you'll see that you're supposed to then, if these records have become super old and you have no use for them and the records retention process is over, you'll see that you have to kind of try and get in contact with the parents or the adult student to either come and get their records or you'll destroy them. We'll talk about that in a bit. By the way, if parents feel that you violated FERPA, they can file an administrative complaint with an office of the Department of Education, if it exists, called the Student Privacy Policy Office. They won't investigate all complaints, but they'll investigate especially complaints that allege a bad confidentiality violation or a widespread one. I also wanted to note that in some special ed hearings, hearing officers can rule on violations of the IDEA regulations on confidentiality. So the general rule is you don't disclose educational records without parental consent. There's some exceptions. Definitely the biggest exception is you can always disclose records to other employees that have a legitimate educational interest in the child. That's going to include contract OTs, contract evaluators, consultants, me. I can access a student's records because I'm acting on behalf of the school district. You can also disclose records to a school where the student seeks to enroll. Don't provide information over the phone. That's not cool. Okay. Verify where the records are going. You'll always have to comply with subpoenas. Those are court orders. If you get a court order and it says provide the student records, you got to. That means that some judge has ordered that. Just make sure they're real. You might want to run those by your attorneys. Health or safety emergency, for God's sakes, tell the EMS guy at the ambulance that the kid is allergic to penicillin or whatever. Okay, that's going to be an exception as well. There's a Supreme Court case where kids were grading each other's papers and the parents said it's a violation of FERPA. And the Supreme Court said, no, every record that is created, like a child's graded paper, is not maintained by the district. We don't maintain every assignment that the child does. So some records are maintained and some records aren't maintained. Under IDEA, we actually, just to get into some nitpicky details, when you have people accessing a child's records and you have to, in special education, you have to maintain a record of who's accessing the records. And you must include the name of the person that accessed the records, the date of access, and the purpose of the access. And the exceptions are parents or authorized district employees. But other folks that are accessing the records, you better have a record of that access. At a certain point, records are no longer needed. Let's say your records retention schedule is passed and it's more than 5 years after you cease providing the child services and you've got a box of records. You have to inform parents or the adult student when the child's records are no longer needed. And sometimes you'll have problems getting in touch with the parents because they've moved and so forth. So, and the law says if the parents want the records destroyed, you must destroy them. But also, what if you just get no contact from the parent whatsoever? They're not coming to pick up the records and they aren't telling you to destroy them. generally what schools do is they publish in the local newspapers some little notice that says, hey, this school district is going to destroy the records of special ed students that were in school from this year to this year. If you're interested in those records, come see us. But by this time, let's say in 3 months, if we don't hear from you, we're going to go ahead and destroy those records. So the law does say that, and I think there's decisions out there that have said destruction of records, although drastic, is a really good means to ensure there's not unauthorized disclosure of the records, obviously, because the records are destroyed. You don't destroy records by dumping in a dumpster, okay? How do we destroy records? Shredding, recycling, that's become very common now. Okay. Some permanent records you always got to keep. The kid's name, address, phone, grades, attendance, classes, the grades that were completed, the year completed. That's sort of you got to keep forever. And you know, in special ed, if I ask you guys, who is your records officer? You better say somebody. And if you don't know that somebody, just say me. Okay. It used to be, I had this, okay, back in the ages when we didn't know too much about 504, I used to tell superintendents, if you get a call from OCR and they ask you, who's your 504 coordinator, and you don't have one, you better say it's you. Okay. You've just made yourself 504 coordinator. The districts have to appoint an official who always assumes responsibility for records confidentiality and make sure that staff that collect and work with records receive training. And that's really important. Last tips, if in doubt whether to disclose a document, ask first, okay? Ask first, then shoot. Read local policy. Assess your email thing. Careful with conversations out in the community. It's generally not a FERPA violation because, I mean, that I talk about my impressions of a child, I mean, that's not stuff from education records, and that's what you can't be releasing, but even an indiscreet disclosure that doesn't cause legal problems can make parents distrustful. And then parents could get the idea that the local school district is just a little mouthy about privacy issues, and you don't want that. So careful about conversations. I have all kinds of conversations with my wife that she doesn't want to hear about special ed students that I'm working on, but I never use names or anything. She doesn't need to know the name or those specific details. So just think about those things. And with that, I leave you.
Yes,
We are at the end of our time, but if there are follow-up questions that are sent to Ms. Eisenhower and she sends them to me by email, I'll be glad to answer them. Otherwise, I thank you. I thank you for your patience and for participating. Thank you very much.
thank you, Jose. And thank you everyone for attending. We will leave this open for a couple minutes. If you have any questions, you can put them in the chat or the Q&A, and I will make sure they get forwarded. Thank you, everyone. Bye-bye. I dropped my mouse. Oh, is it possible to get a recording of this meeting to refer back to? Yes, it will be posted on our, what's it called? Wyoming Instructional Network. And if you go to Wyoming Instructional Network, WIN, there's an archive and it will be posted as soon as it's ready. And when you say a copy of the presentation available for participants, do you mean, Betty, a copy of the PowerPoint or a recording?
Of course, Ms. Eisenhower, you have my permission to send copies to all the participants.
Thank you, Jose. Jennifer, we have all their emails, so we can send out a copy of the presentation.
Yes,
and
yes, we can. Yes.
It says, were you going to send a copy of the Q&A? There were no questions in the Q&A other than housekeeping kinds of things, me trying to get those links posted. But I will send along with that a copy of the Wyoming retention schedule because I know we have it. I've seen it. Any other questions? I dropped my mouse. Hold on. I gotta scroll down, but
It's under the mountain.
there it is. That was loud. All right. Uh-oh, now it's not working right. Uh-oh. Okay, either one. Copy of the PowerPoint. Okay. We will send out the PowerPoint. Thanks, Jose. It's good to see you.
Thank you all. Have a
Bye.
nice one. Bye-bye.
You too. Who do we have? We've still got 10 people
Yeah.
on. Let me look. Oh man, the
Yeah.
battery fell out of it. That's why it's not working. Let me use
We're
my
down
old.
to 7-5. Yeah.
Sometimes people turn it on and then they go and do things and
Yes.
they
Yes.
have to be
Yep.
nudged off. Thanks, Jennifer.
You're welcome.
Okay. All righty. Have a good evening.
You too. Talk with you later.
Does it stop recording when we end it?
It should. Yeah.
All
I can
right.
go ahead and push stop recording.
Okay.